Okay, so thank you all for sticking it out till the near bitter end. Also, I know you had your choice of patent panels and none other, so thank you for choosing this patent panel. Today I want to talk about patent challenges, placeholder suits, and entrenchment. For that, I think I should explain what some of those words mean. So let's start with what is a patent challenge. A patent challenge is, and you've probably heard of all of this already, but I'll go through the background. A patent challenge is when an alleged infringer sues first seeking for declaratory relief. Why would they do this? Primarily so they get their venue of choice. You're a California company, an Eastern District of Texas company sends you a demand letter. You say, we know we're going to get sued. We better file first in the Northern District of California. We're going to get our venue. Also, you get to be the plaintiff. You get to go first, usually, often, depends on the judge, but you get to say you're the plaintiff. So there's a reason why you might want to do this. It turns out that the rules have changed for when you get to file a patent challenge. Before MedImmune, which was at the very beginning of 2007, this is MedImmune versus Genentech, it was a higher standard. You had to have an imminent threat of lawsuit. After MedImmune, it was a lower standard, or some might say the declaratory relief standard. It had to be any justiciable controversy. In other words, it was easier to file a lawsuit on a less harsh demand letter. So, what are some patentee responses to the lowering of the standard? Well, there are three potential responses. The first is no change. Sending the same demand letters you sent before. The second is to send softer, vaguer demand letters. I think this has happened in large part when people complain today about getting demand letters that don't mention the patent that's been infringed, etc. I think you can blame MedImmune for that. A third option, and the one I'm studying, is to sue first, demand later. And this leads to the second term I'm defining. This is a placeholder lawsuit. The idea is if you sue first but don't serve it, you have some number of days before you need to sue. You can then send a demand letter. You can send it as harshly as you want, because when the other party files their declaratory relief action, it doesn't matter. They were second in time. You get your choice of venue in, for example, the Eastern District of Texas. So, what are some costs and benefits of placeholder lawsuits? General. A benefit is their signaling. The person who files the lawsuit is signaling they are serious. They're serious enough at least to go to court and file a lawsuit because they have now committed themselves. This is a sort of potential transaction cost reduction, maybe more likely to lead to settlement. But there is a potential cost. It might lead to entrenchment. You've now filed a lawsuit. The other side may dig their heels in and say, you know what, we're in a lawsuit, we might as well fight this thing out. This is a transaction cost increase. The question is whether or not which of these things outweighs the other. There is a conventional wisdom that there was more of the placeholder type filing after MedImmune, but we don't really know. So that's what I ask in this paper. I want to test using differences in lay terms that basically says we've got two groups, and they don't have to be filing at the same rates, but we would expect that one group will be affected differently after our treatment. Our treatment here is MedImmune, and if they are, then we know that MedImmune had an effect. So we're comparing behavior before and after MedImmune, and my two groups are between regular patent plaintiffs, a random sample, and highly strategic patent licensors. which is another way of saying, at least for those of you familiar with my work, the top 10 most litigious non-practicing entities from the first half of the 2000s. So basically, I'm leveraging the data set from my patent troll myths paper, my generation of patent litigation paper. Ironically, one of the biggest knocks against those papers is the selection effect, because I'm not looking at all NPEs, I'm only looking at the top 10 most litigious, the most strategic. It turns out that's a perfect data set for this, because I want the most strategic. I want the people who are most likely to behave differently, because then I can test and see whether they did in fact behave differently. So, the problem with measuring placeholders is we cannot simply count declaratory relief cases. And by the way, by the time the project is done, I'll have a pretty chart which has all the declaratory relief changes before and after. We've been gathering it up this summer. On the one hand, because declaratory relief cases are easier to file, there should be more. But because we might have more placeholders, it means there might be less. Because once you find out there's been a placeholder filed, you need not bother filing in your own jurisdiction. So instead, what I'm doing to try and measure this is to look to case duration. Do we see a spike in short-lived cases? Are cases getting shorter? So here's my null hypothesis. If metamune has no effect, then the relative differences in duration between the random litigants and the highly strategic licensors will remain unchanged. If metamune has an effect, then the opposite will be true. The relative differences in duration will be different. So this study, I've already given you a preview. It starts with the most litigious non-practicing entities of 2003 to 2009. We identified all of their cases, which goes back 25 years. I matched those with non-NPE litigation over the same proportion over the 25 years. I identified all of the non-NPE cases asserting the relevant patents from an initial group. It's a long, complex thing. You can read about it in other papers if you're really interested, or we can talk about it later. The last case filing was 12/31/2009, which leaves very few open, which means we have good duration data. Here's the summary. For the non-NPE, we have 1,313 cases versus 917, for 792 patents versus 352. So, here is a chart of case duration. It's the mean number of days to resolve. It's the log of that. It turns out it's perfectly logarithmic, the number of days. Like, if you look at the graph, you would not believe how close to a normal curve the log of the days is. One problem you see is over here. This is not your typical differences in differences story. So if we're looking at full duration, the numbers are not looking good for us. And in fact, that's what we find. So here are some preliminary results, which I'll explain in a second so you don't get all afraid of the numbers or your eyes don't glaze over. They're preliminary because these numbers include declaratory relief cases, which I need to exclude because by definition they can't be placeholder cases because the party filed first. So, I don't think the numbers are going to change, but we've been gathering that data all summer. So how do we interpret these results? Well, here's what I did. I tested whether case length based on some controls, the number of defendants, that would change time. The number of patents, that would change time. I did 2 regressions, one without it, one with. You see it makes no difference. I tested whether or not non-practicing entities have shorter or longer duration. It turns out they're shorter duration. These are percentages. So in this one, the non-practicing entity is, on average, 81% of the duration of the practicing entity. The duration doesn't get shorter after metamune, it gets longer on average for all the parties. This is the differences in differences. We test, are they one of our licensing entities? Is it after metamune? If that number is bigger, is smaller than 1, then the duration got shorter. And that's what we're testing for. It turns out durations did not get shorter. They got longer. NPE litigation got longer after metamune. So if we just look at total case length, we can't make any determination that there's more placeholder suits. It looks like there's entrenchment instead, if anything. But I looked at this a different way. Here what I did, I don't know if there's no laser on this, at the top was I measured the number of lawsuits that ended within 30 days, that ended within 90 days, that ended within 180 days, and that ended within 365 days. Now here, what we would expect is that if there are placeholder lawsuits, we will have an increase in the percentage of suits that settle quickly. Because you file suit, you send the demand letter, you settle. And it turns out that's what we find. Suits that end in 30 days, there's actually fewer for the NPEs. But if you look at suits that are 90 days or less, there's actually more of them, only 5% more. But there's more of them for the NPEs. It's about the same for 180, but look here. Only 75% of the suits finish within a year now, as compared to before for the NPEs. So here's my interpretation of these 4 regressions, my preliminary interpretation, that there is, in fact, placeholder suits that are being filed. We do see some shorter litigation, some quick settlements, but also if there is placeholder litigation, but even if there's not, you see more entrenchment, so we are seeing fewer cases than we did before that are settling within a year. So we're seeing a few more that are settling within 90 days, and a lot more that are settling more than a year later. And that's basically it. That's the last slide, I think. So I think the takeaway, and what I hope to develop by the end of this project, is what's driving this, especially what's driving the longer cases. Is it entrenchment? Is it just that people are challenging and not settling the NPE cases? I have other data on this. Or is it placeholder lawsuits are sometimes leading to settlement, but otherwise leading to long cases? That part is a little bit ambiguous, which is always a little bit unfortunate. Okay. Thank you. Yes, TJ.
So I think there's definitely a phenomenon here, but I'm trying to figure out the definition you're using and it affects how you interpret the results, because
Okay.
What's your definition of a placeholder lawsuit? I mean, the paradigmatic case is you file it to preempt a later declaratory judgment,
right.
And then you send the demand letter and you settle.
Right.
Right, what if they don't settle? Is that still a placeholder lawsuit? Does it turn basically on whether you whether the intent is to preempt the later declaratory judgment, because you don't actually know whether they're going to seek declaratory judgment.
Well, that's right.
Right, it's a bit difficult to correlate the case duration with what the patentee is trying to do at the time of filing that, because every patentee tries to get its favorable venue. Like,
right.
That's just human nature.
It is, you're right, it is difficult. It is a proxy. So I'm using as a proxy a short-lived,
A quick settlement.
a quick settlement. You're going to have quick settlements anyway.
Mm-hmm.
So that's why I'm doing the differences and differences. We're always going to have quick settlements. I mean, the fact that you are an NPE says on average you're going to have twice as many quick settlements. So what I'm measuring is, after MedImmune, do we see an increase in the number of quick settlements among just one of the groups?
Let me,
So does it match totally with the placeholder? You either buy into that use of the proxy or you don't. I think it's a reasonable proxy because that's what people are doing.
Add one more variable to that, which is after MedImmune, is there any reason that practicing entities will file more placeholder suits as well? In that, if I'm a practicing entity, I still want my preferred choice forum. Now, I don't get to locate in the Eastern District of Texas, but I probably want to sue close to home just because juries like local companies and all that. So, I mean...
Well, yeah, what you're saying is if you don't buy into the view that strategic companies would be more likely to file a placeholder lawsuit before sending a demand letter, then you're not going to buy into the differences in differences. I can't change that.
Okay.
I mean, there's nothing I can do about that. I believe that to be a phenomenon, but you're right. It may not be. Now, I can put all the data together. What I find is that post-MedImmune, there are not more cases that settle within 90 days among all entities when you put them together. It's only when we separate it out.
Okay.
Yeah, the numbers always get me.